Good afternoon and a very warm welcome to what is the second last of our FSC conference ReGenerations program. We're sitting here on the 13th of December at 3 o'clock, and as we've done for the last 3 or 4 months as we've been running these programs, great programs like this can only happen with fantastic support from the marketplace, and wanted to acknowledge our very generous and supportive sponsors. I think everyone knows we've had to, given COVID, move this event from face-to-face to an online and then a fully online show. So I wanted to thank our sponsors, obviously wanted to thank our speakers, and of course wanted to thank the delegates for turning up, and the support's just been amazing. So I think for all of us, we've learned a whole bunch through COVID, and the ability to deliver very relevant, very pressing, very timely content has been one of those blessings, and you don't need to have people in the same physical room. And so today's session, let's flag to that. I'm absolutely delighted to introduce today's session, which is all about the new financial advertising guidelines, looking at some insights and understanding some of the changes and the opportunities. And delighted today to be joined by Hilary Souter, who is the CEO of the Advertising Standards Authority, and Paul Gregory from the Financial Markets Authority. Very warm welcome to both of you. The way we'll run today is that both Paul and Hilary will discuss and present for 10 or 15 minutes each, and then we're going to have an open forum, open discussion, and like with all things in Zoom land and so on, totally welcome people to join the conversation, join the chat. If you're new to Zoom, just use the Q&A or chat button. If you're not new to Zoom, feel free to join the conversation. We'll absolutely be led by some of the ways that the audience wants to take us. So without further ado, again, really interesting conversation on advertising standards. I'm going to hand to Paul Gregory. Welcome him. Paul's been a fantastic supporter of the FSC now for all of his tenure at the FMA, and he's going to open the batting, if you will, on the FMA's view of some of the new changes. So Paul, welcome, and over to you.
Thanks, Richard. Thanks, everyone. Kia ora tātou. Thanks for tuning into the seminar. I'm Paul Gregory, Director of Investment Management and also currently Acting Director of Capital Markets for the FMA. And I wanted to talk about why a financial markets conduct regulator cares about advertising, what we expect of issuers to ensure their advertising is consistent with fair dealing and good conduct, and what we can do if our expectations are not met. So this just sets our approach in the context of fair dealing and of conduct generally. So a financial product means debt securities, equity securities, managed investment products, and derivatives. And an advertisement is broadly defined in the FMC Act. In relation to an offer or an intended offer of financial products, it's really any communication to the public or section of the public for the purposes of promoting the offer or the intended offer. And it can be via any medium, and that includes social media, mobile phone messages, or presentations. Also, the fair dealing provisions say persons involved in advertising for a financial product can be liable, which means directors and senior managers can be liable for misleading advertisements by the issuer if they aided, induced, or otherwise are directly or indirectly a party to the misleading advertising. But why have guidance for advertising? The FMA has talked in many places and often about the asymmetry of information between providers and investors being a major source of potential harm. And of course, with managed investment products, that can be harm which lasts for a long time. Advertising is probably the most acute expression of that asymmetry. The weight of information on the provider's side is compounded by advertising being consumed incidentally, impulsively, subconsciously, which is why it works, and which is why providers spend so much money on it. The scales are already tilted heavily toward the provider. A product being complex, the use of jargon and fine print put more ballast on the provider's side. Add the art and science of online and social media advertising with search optimization, with Facebook and other social media targeting algorithms, and input from marketers on staff who are qualified in utilising behavioural science to manipulate biases, advertising can be particularly potent. And what does the customer have to counter that? Certainly not advice. No one calls their advisor, even if they had one, about an ad. The customer has nothing other than innate reasoning, which can be reduced by personal vulnerability or situational vulnerability, like, for example, right now, people needing yield. So when advertising a financial product, it's useful to keep these principles in mind. First and most important, it is the overall impression which counts from a fair dealing perspective. It's important as well to understand impression on who. The test is an ordinary and reasonable member of the advertisement's audience. And audience does not mean who the advertiser is targeting, but who the advertisement reaches, which is quite interesting for social media, where you can choose your audience, or at least its characteristics. And it's the first impression which counts, not the impression after thinking hard about it, or the impression after reading supporting materials, white papers, and the website. You have to be careful what you leave out, not just what you include. And you can't just hint or make bold claims or editorialize. Fair dealing provisions require representations in advertisements to be substantiated. There must be a reasonable basis for it, and it must be present when the advertisement is made. An advertisement cannot be substantiated after the fact. So the FMA's expectations about how the principles are applied to advertising financial products are many, but I'll just pick a few. First, you need to balance risk and reward. Advertisements should not say a financial product is safe, it's risk-free, or it's low risk, or it's so low risk as to be effectively the same as safe or risk-free. Returns cannot be guaranteed. Don't overemphasize performance. Short periods are particularly problematic. We're always interested at the FMA to know why an issuer wants to advertise short periods of performance. It's very difficult to avoid the impression of asymmetry of information as attractive for the provider here. Fees and costs should be clearly disclosed and not create an unrealistic expectation about what an investor is likely to pay. And any claim of no fees is hollow if the issuer earns money from the financial product, like fees for lending, or they receive all the return above a fixed return for investors, which on the face of it sounds okay, but might in reality be a tiny slice of the actual return on a higher risk investment. So even if they're getting a 5 or an 8 or a 10% return, the reality might be a lot of money is being left on the table. And so it's not appropriate to say there is no fees. Finally, wholesale offers should make very clear they are not available for retail investors. And the channel matters too. Do real wholesale investors really pick up their opportunities off Facebook or from regional print media? Again, it's how the advertisement is advertised, not just what's in it, which counts. The FMA has a variety of regulatory tools available to address false, misleading, deceptive, or confusing behaviour in advertisement. Action taking will depend on the severity of misconduct and other factors such as, is this a one-off or is it part of a pattern? We have stop orders, which must be published and prohibit the user from continuing the relevant activity. On the basis stopping it protects investors and the integrity of the market. We can stop distribution of a PDS. We can stop a provider from continuing to offer a product. We can stop a provider from accepting applications or deposits for a problematic product. We don't need to go to court, and failure to comply can result in a fine of up to $300,000. Direction orders are intended to change behaviour by directing compliance or specifying steps to be taken. Again, these can be public. And court action is possible for more serious breaches. Under fair dealing, they are all civil liability provisions, which can result in a pecuniary penalty order or a compensatory order. So ultimately, financial product providers and the FMA want the same thing. If investors and customers are treated fairly, issuers benefit, the market benefits, the economy benefits, and that benefit is sustainable. Benefits that accrue to financial providers based on inaccurate or misleading advertising is brittle. It's not sustainable. Good regulation and good conduct address the information asymmetry and right the scales back on balance between the investor and the provider. Thank you for that, And now I'll hand over to Hilary.
Thanks, Paul, and thanks to Richard and the Financial Services Council and the FMA for the opportunity to join you today to talk about the Financial Advertising Code at the ASA. The ASA is a self-regulatory organisation. It was established in the 1970s by television, newspapers and the advertising agencies. And today we have 6 different codes that we administer. The Advertising Standards Code is the overarching code for all ads. And we have 5 specialist codes, including the Financial Advertising Code. We are funded by levies, so the advertisers pay a levy to the ASA based on media placement costs, and that's 0.065% on the spend, and that's collected by advertising agencies for us, and we also have support from the media organisations. If anyone's wondering and they want to know the difference between the BSA and the ASA, the Broadcasting Standards Authority is a statutory entity and it looks after program and editorial content on radio and television. If you could go to the next slide, please. So we're here to support consumer trust in advertising. It's really important for us to we look over and above the legal requirements, obviously, of which there are many in the financial space and appropriately so. The FMA is obviously a senior jurisdiction to the ASA. And for us, it's interesting. We're more likely to receive complaints about matters not relating to finance in financial advertising. And I'll talk a little bit more about that later. We have a tripartite process, so advertisers, advertising agencies, and that includes creative and media agencies, as well as media platforms, members of the ASA, and they are all responsible, as far as we're concerned, for the placement and content of that advertising. So when we get complaints, we're usually talking to the advertiser, the agency, and the media. And we're really lucky to have strong engagement from the industry with our process. For example, the 2 major advertiser associations are members of the ASA, the Marketing Association and the Association of New Zealand Advertisers, along with the Communications Council representing the agencies. And the ASA has 11 media sector members, which cover most of the main companies in New Zealand. In the next slide, I've just given a quick breakout from 2020 to give you some context on numbers that we deal with. So unsurprisingly, we get multiple complaints about ads, so often more than one complaint about an ad. So 591 ads looked at last year, 1,151 complaints. The chair has the ability to determine whether or not there's a case to answer in a triaging process that we run. So the chair of the complaints board, who's a public member, reviews the complaint and the advertisement in the context of the codes and makes a decision on whether or not there's a possible breach. If we accept a complaint to be determined, we write to the advertiser, the agency and the media and ask them to respond within 7 days. That information goes to the complaints board, a 9-member board, 5 public members and 4 industry members, and they make a determination. If the complaint is upheld, we ask for the advertisement to be removed. We have a pretty good success rate, even though our process is voluntary, and it helps that we've got the support of all the media platforms in terms of compliance. But most advertisers are willing to accept, well, I'm not sure willing is the right word. They accept the decision and gracefully make the changes to the ads. We also release the decisions to the public and the media through our website. We have a searchable database on the website for all the past complaints back at this stage to 2015. And the complaints board meets fortnightly. So every 2 weeks we have a complaints board meeting, which enables the complaints to be dealt with in a reasonably quick time frame. It's not designed to be complex and overly legalistic. And as Paul mentioned, it's a really key part of the process, the consumer takeout. We dealt with, under the code in 2020, we dealt with 12 advertisements in the financial category. So it's not a big part of our work. we have other areas that drive more complaints to us than the financial advertising. And the next slide, I've sort of drilled down a wee bit into our definition of financial advertising to help people understand where we sit with it. And this is actually an adaptation of our main definition of advertisement in all our codes. So the keywords here, obviously, because they're highlighted in red, are the word control and the word intent. It's really important to us that the advertiser has control over the message. We do see from time to time, particularly in the social media space, sometimes fan pages. I'm not saying that's a common thing in the financial space, but certainly in some of the other categories that we deal with, it is. And the advertisers themselves generally have no involvement or control over that content. And that's a factor for us in determining whether or not we would look at whether we would take jurisdiction over the advertisement or the complaint. An example for us in 2020 and 2021 has been the influencer work that we've done. So this is a category of advertising that's come to the fore in the last couple of years. And we sometimes have a discussion with the advertiser or the influencer about whether or not there is advertiser control over the influencer post. And an example in that space for us is around whether or not the advertiser has chosen to engage with the influencer, possibly through a promotion, through an offer of a free product or service or access to a service. And for us, that's sufficient to make the connection and to give control. So the advertiser's chosen maybe 50 influencers to engage with in this space. They may not be able to directly control what the influencer then says, but they have and made the initial contact. So for us, that would be a sufficient trigger for us to look at in terms of jurisdiction. And mostly for us in the influencer space at this stage, we're looking at ad labelling. It is really important for advertisers and influencers to understand where the content could go and the risks around that. And particularly in a highly regulated space such as financial advertising. I think it's really important for advertisers to understand that not all influencers are aware of the restrictions that are applied to certain advertising, and certainly not necessarily familiar with the financial markets legislation or possibly even the Fair Trading Act. As the influencers get more work and have representation through agencies, some of that's changing, but it is something to be aware of. The next slide goes into the key principles of the advertising code. So it's pretty straightforward. There's a principle around social responsibility and there's a principle around truthful presentation. I haven't drilled down into all the rules. The code is on the website, asa.co.nz. And the intent behind it is to highlight our partner processes, really. So the claims should be accurate and truthful, and those rules drill down into what we mean by that. And the social responsibility rule is more about the protection of vulnerable people. And in that part of the code, we also include rules that are drawn in from the Advertising Standards Code. So something to be aware of, that if you're advertising in this space, you need to be familiar with the Advertising Standards Code, which covers all ads in all media, as well as the code that applies to financial advertising. So the two go hand in hand. The Financial Advertising Code was released in November, and it comes into effect for new advertising on the 1st of March 2022 and for all ads on the 1st of June 2022. So until 1 June, we'll be operating parallel codes, the existing code for financial advertising and the Financial Advertising Code. And we've had a code in the space since the early 1990s. When the board and the Codes Committee were looking at the review of the code, we did have a discussion and some contributions from some of the submitters on whether or not it was actually required, given the robustness of the legislation in this space. And On balance, the committee decided there was value in providing a code as a further layer of protection for consumers. In particular, the requirements around social responsibility is something that we think it's quite hard to legislate for. And perhaps the code gives more options in that area for us to look at. And that would apply also, as all of the codes do, to the content and placement of advertisements. And Paul talked a bit about that as well. This code is not radically different from the earlier code, but we undertake reviews on a regular basis, and the review of this code was due. It's important to think about things like, for example, in the Advertising Standards Code, we have rules on privacy, decency and offensiveness, safety, and fear and distress. And you may not consider that those rules could apply or be relevant to financial advertisements, but our complaints would say otherwise. On the next slide, I've just drilled down a little bit into the types of things that we've picked up in the code. So certainly the definition of what financial products and services is drawn from the legislation, and it goes into quite a lot of detail. And we formulated that in consultation with the submitters, and that was really helpful. Much more detail than usual for us, and to try and sort of communicate the breadth of the products and services that are covered, and it will also apply to new and developing products. One example of that is under the old code, there was a little bit of ambiguity around which insurance products were covered under the financial products and services banner, and the committee has clarified under the new code that all insurance products are covered. Just a heads up there. The focus for us is the consumer takeout. It's the first thing the complaints board looks at every meeting when considering a complaint. They'll discuss the consumer takeout. And as Paul mentioned, not necessarily what you intended, but what the actual, what the consumer's interpretation was. I'm very aware that the advertisers put a lot of resource and planning into ad campaigns. And what I would say is that, and what generally happens is the people who are involved in those campaigns have a really clear vision of what they're trying to communicate. And the end product to them does exactly what they wanted it to do. What I would say, if you don't do this already, I think it's really helpful to talk to people who are outside of that team, who can provide you with a non-expert takeout of what you're trying, and give you their view of what they think the material you've put together says. And it may not be what you intended. And I think that can be quite a useful sense check for people who get very close to the kind of material they've pulled together and may lose a bit of perspective on it. I think it's a really easy thing to do, and it's, just a really good box to tick in terms of making sure you're aware of what interpretation people might put on your messaging. The next slide just covers for us a few issues that are raised in ads that we deal with. Recently, we've had the use of stereotypes flagged with us. So particularly perhaps how women and men are portrayed in advertising, and sometimes issues around a role reversal, which is quite interesting. There's the ongoing challenge around ad identification, which we've talked about with influencers. But by the way, that applies in all media. So we're obviously aware of sponsored content environments, what some people call native advertising. There's a raft of different techniques that are used in different mediums. In all of those mediums, there's a rule that requires advertising to be identifiable as such. So that's something to be aware of if you're in that space. We also have some concerns around platform limitations for qualified offers, personalisation of advertising, which has raised some issues in terms of perhaps using a platform subscriber base. There may be the right permissions in place in the platform's terms and conditions, but some people are put off by this level of personalisation. And obviously, if you can't prove it, you shouldn't be saying it. And the onus for us is on the advertiser to prove any claims in the ads, not the complainant. We do have a guidance note on misleading advertising, and it includes information on the types of substantiation that may be required to support qualified or absolute claims. And just finally, in my last slide, just confirming all ads, all media. In my experience, most advertisers are keen to get it right before anyone sees the ad, and they do take complaints that we send them seriously. I would encourage you to engage with the ASA if you receive a complaint. We're happy to provide information about our process and code compliance, including options available to you. Sometimes mistakes are made, and in our process, the advertiser can acknowledge that and remove or change the ad, and the chair of the complaints board is likely to settle the complaint. A short ruling would be published to that effect, but we wouldn't put that complaint in front of the board to debate whether or not there is a breach of the code, because the advertiser's already put their hand up and said they made a mistake. Those rulings are also published.
That's brilliant. Thank you, Paul, and thank you, Hilary. Hilary, I'm going to start with you if I can in terms of some of the questions. Just picking up the complaints that you mentioned, that there were 12 in the financial services sector. Can you just give a bit of a flavour of some of those things and maybe counterpoint that with, a non-financial services sector which clearly fell outside reasonableness or the asymmetry piece?
Look, I think one, so an example, I just printed out a few prior to the presentation. We looked at an ad for one of the financial companies, which the complainant thought was implying that being frugal is foolish and that using a credit card is more financially sensible. And that complaint was actually accepted and went through to the board. And the advertiser defended the approach they'd taken in the messaging, the context of the messaging they'd put across. And the board accepted that that was the takeout from the consumer who'd complained. It wasn't the likely takeout for most consumers, and that was not upheld. We've recently dealt with a complaint about a bank talking about the move to, the fact that cheques are no longer accepted. And the advertisement had a person talking about, cheques and cash have sort of gone by the wayside, and now it's, electronic payments are much easier, and trying to encourage people to look at a banking app. And one of the complainants said that they felt that the implication or the takeout for them from the ad was that that you could no longer use cash, that along with cheques, that cash was also, on the out. And the chair said she didn't think that was actually the likely consumer takeout, that while perhaps it could have been worded a little bit differently, that was quite a, that didn't really, wasn't the likely takeout for most consumers seeing the ad. There was quite a clear emphasis on the available, what the app could do and what you could use that for.
Yeah, and Hilary, just a further one on that. I mean, I guess what you're saying is that if organisations are spending money on advertising, they obviously want a return, but they also want to do the right thing, because the reputational damage of doing the wrong thing not only costs you not doing the campaign effectively, but then it's going to cost you a whole bunch of other grief as well, yeah?
Look, absolutely. And I think that people are, reputation management is a very big part of a lot of companies' work. I think that they are very aware of the risks around having an advertisement found in breach, I'm sure, of the FMA and hopefully the ASA codes, and then the resulting publicity around that. I think there are some small steps you can take at the start to really really almost, certainly not eliminate, but make a significant reduction in the risk that you're running that could happen.
Yeah, thanks for that. Paul, did you have any comments on that part of the conversation?
So obviously, the decisions that we've taken have tended to be public. So, people would know the recent incidences where we've had problems with advertising, and obviously, as I've said, direction orders and stop orders and the like, that they do tend to have a public aspect to it, because it's not only about preventing the behaviour of one provider in the market, it's about sending signals about what is not acceptable to everybody in the market, so that that there's that sort of object lesson part of having a playing field, as well as having consistent rules and limits that apply to everybody.
Yeah, great, thanks. Hilary, I'm just going to go back to you. There's a question here from Emily around just wanting to explore a little bit more personalisation. Can you give an example of an ad that might have been personalised? And thank you, Emily. Any other questions, keep them coming.
So, look, we did have and it's on the website, there was a complaint actually that was to do, in fact, with in the end it was settled through a media error. So TVNZ On Demand has a ability for advertisers to personalise their advertising. So you could have an ad pop up during if you're watching TVNZ On Demand with your name on it. And that's not, the advertiser doesn't have access to that information. It's that particular, the names are dropped in by TVNZ as part of a process they offer. And we had a bank that made use of that option, and we had complaints about that. People found that quite disturbing, that they're watching a TV show and an ad comes on and their name comes up on the ad. And that sort of, I think you've got to be careful to, it's one thing to do a targeting option, and depending on the medium you're using as well, with people and having a one-on-one conversation, and then another in perhaps a broadcast environment's a good example, where people feel it's more like stalking as opposed to targeted messaging. So there's a process you can go through to do it, but I think advertisers need to think about whether it's a suitable tool to use, particularly in the high standard area where there's some risks. And I guess one of the things about that is that you don't always it's quite a blunt instrument, which could have some repercussions, I think, that might suit advertising for a more general retail, an everyday product as opposed to a financial product.
Yeah, thanks. Because for all of us on various social channels, it gets, the algorithms are very pointed, they're very specific based on your usage and your interest and so on, right? So what might appear as a interesting article actually is probably there because of my habits, for example, or someone's habits, right?
Yeah, and look, there are tools that you can use to manage that or reduce that. And some people actually prefer it. They'd much rather see an ad for a business that they're more likely to engage with than an ad that has nothing to do with their interests or things that they want to buy or places they want to go, so that it might suit them. But yeah, I think it works. It might work for a product where you're thinking about whether you want to do some change your cleaning product, as opposed to something in the financial space where there's a raft more controls around what's appropriate and what's not in terms of people's individual circumstances.
Yeah. Hey, there's a great question here from Helen, and Paul, I might go to you first on this one. And this is about the ASA and the FMA working together to ensure consistency of message and the standards applied. Well, I wondered whether you could both comment on that. Paul, maybe start with you.
Sure. Yeah, sure. So we certainly worked with ASA. We're putting our guidance, and I think that we're both here together in this very forum shows that we are keen to make sure there is a consistent message, because particularly when there are consequences, and both ASA and ourselves have the ability to apply consequences, that there should be a consistent treatment. So it's important to the FMA in terms of working together with the ASA.
Great, thanks, Paul.
Absolutely. I think I'd say also that we do probably come at things from slightly different angles, and that, because we're actually reflecting compliance with our code, not with the law. And if we did get a complaint actually where people raised something that was more appropriately dealt with by the FMA, we would refer the complainant to them. That if we are aware of our limitations, and the service that we provide is not all encompassing, and the point of the city jurisdictions is sometimes their reach and power is required, and we would be more than happy to engage with them to if they're the better jurisdiction for a complainant to go to, we would certainly have a chat to them about that.
Yeah, and obviously, Paul, to your earlier point, the FMA can use the tools in your arsenal a whole lot more quickly, if you will. As you see something turning up, you can effectively take action straight away, right?
Yes, that's right. Time can be pretty rapid, and of course, if we believe or if it's clear that there is existing harm, then we need to quickly, yes.
Cool. Folks, I'm just going to take us into a question just as we went through the consultation process back earlier this year. Just interested in what were some of the key issues raised by the submitters. And Paul, again, I might start with the FMA piece first, and then Hilary, to you if I can.
So the most prominent themes for us are related to the scope of guidance. So was it regulated versus unregulated offers, offers made to wholesale investors, short form advertising, statements made about performance history and forecast returns. So a lot of submitters wanted clarity that the guidance didn't apply other than to financial products. Many submitters argued that given the character limits on social media and other online advertising, and the reliance that many firms place on using online advertising, that the FMA's permission shouldn't make it difficult for financial product providers to engage with their customers through those channels. And then on wholesale investors, we had many disagreeing with our position that the warning statement needs to be immediately and prominently clear. Some also disagreed with our position that an advertisement must state that an offer is not suitable for retail investors. So that's the main themes of the feedback that we got.
Thanks, Paul. Hilary.
So I would say that for us, the key things were the need for the code to cover a really broad range of financial products and services and not be limited. We also looked, and people raised with us, the protection for non-expert or vulnerable consumers. And we talked too about the risks relating to short form advertising. And I think on that, the committee had a particular view on that. They reflected in their report. Ads have to stand on their own merits, and I think there can be some risks depending on the kind of information you want to place elsewhere or on a link. There are some risks around that. So if a product or an offer is quite complicated, if there's a lot of detail or qualification around it, then I think companies need to think about what is the most suitable platform for that advertising. And it may not be social media. That doesn't mean the brand can't engage with people on social media for a variety of ways, but depending on the complexity of the service or product that's being offered, then maybe some thought needs to go into the best platform to get that message out there in a comprehensive and way that's not going to be misleading.
Yeah. I might just turn to both of you raise the notion of finfluencers, and Paul, the FMA has put out some guidance and had a good conversation about the role of the role of people out there who are either self-appointed or perhaps appointed by advertisers to kind of represent their brand, but it's not always obviously apparent. And of course, if you're an influencer, you're monetizing your brand and so on. I mean, how do we kind of separate out the finfluencer from the story they're telling, if you will? And how does it get captured in this discussion?
If it's a recommendation, then from the perspective of advice, that it needs to be based on some understanding of the circumstances and goals of the person that you're talking to, which can be pretty difficult in the influencer format. So it's just about being extra careful about what you're saying and who your audience is and who you're talking to. So I think there's just extra caution that needs to be on both sides in terms of the person who's doing the engaging with the audience and the people who are listening, which is that what is motivating the person to make this recommendation, where is this coming from, and just some natural caution that this person doesn't know my circumstances, they don't know how old I am, they don't know anything. So just some natural skepticism is necessary, I think, when critically assessing what's being said and who's saying it.
Yeah, thanks, Paul. Sorry, Hilary.
Not at all. Look, the work that we've been doing in this area is really around a small number of companies who have used influencers for product promotion, not financial advice per se, but talking about a product that they've got and that they like and they use and how they use it. And the issue for us was around labelling, so that it wasn't clear in a space where there's a mix of organic and paid content, what was advertising and what wasn't. So, and we had a couple of complaints around people thinking that perhaps just putting something in a bio area in a social media space would be sufficient, talking about hashtag partnership or hashtag SP, hashtag gifted, and our guidance is pretty clear. We have 3 suggestions. We think you should say ad, advert, or advertisement, and anything else is kind of dressing it up and doesn't really help the consumer understand the commercial nature behind the relationship.
Thanks, Hilary. Just picking up that theme on complaints and what's come across your desk. Are they good things that you're seeing? Are there interesting things that you're seeing with organisations responding effectively to both the new platforms, but also looking to really target their message and identify whether it's financial services or not?
I think it's still a learning curve. I think that my perception would be that most of the companies in the space are approaching it pretty cautiously, with I think pretty high degree of awareness around the risks given the regulatory framework. So we don't see many examples of it, and I think that's a good thing. I think our experience generally overall is that the advertisers that come back to us have got a pretty good sense of what they're required to do, what the expectations are around their work, and approach it pretty cautiously.
Yeah, great, thank you. Paul, can we just talk briefly about the convergence? It came up much earlier this year with the GameStop discussion that we had, I think, at the breakfast that we had maybe at the end of January, early Feb, and it was this kind of sense of remit that there are international players that are advertising in New Zealand on New Zealand platforms, the GameStop example was one. Crypto is obviously filling the airwaves with lots of advertising. What's your sense of the FMA's take on how to manage a remit creep when their entities may not be jurisdictional here in New Zealand?
Yeah, well, our powers are obviously for advertisements by New Zealand-based providers, either of financial products outside of New Zealand and within New Zealand. In terms of entities that are outside of New Zealand and have reached New Zealanders here, it's largely about warnings, and so we those are things we can do pretty quickly. but it really is a caveat emptor there in terms of, and that underlines lots of other messages that we've done about user license provider, that sort of thing. Again, it's that sort of critical awareness of who is offering me this, why are they offering it to me, if it's too good to be true, all the sort of standard judgment-based questions that you should be asking about these sorts of things. But the reality is that if it's an offshore-based provider, that warnings are as far as we can go.
Thanks, Paul. Hilary, any comments on that one?
Just to say, we would look at, if it was published in New Zealand media, we would look at engagement with offshore providers over the advertising if we received complaints, because the media can help enforce those decisions, even if the advertiser doesn't engage with us. So it is possible. We've got a few examples, not necessarily in the financial space, but certainly in some other categories where we've gone down that pathway.
Yeah, great. Thank you. I'm just going to take us to this question around grace periods. Both of the codes, etc., are going to be operational. Can you just, perhaps Hilary, start with you? You mentioned a little earlier on the March and June timeframes of next year. Can you just perhaps expand on that a little further?
Okay, it's a standard thing that we operate, and it really has to do with the long lead times that some of the advertising has. So there could well be, and I would actually expect that some companies may well have advertising for Q1 and maybe even Q2 already in the can now. So bringing in a code change that requires a quick turnaround is pretty challenging in that space. So we tend to allow sort of a 3-month time period for people to kind of get their ducks in order, and hopefully we've signalled any changes coming to them for new advertising, and then all of their advertising should comply within 6 months of the code launch.
Yeah, thanks, Hilary. Paul, any comments you want to add from the FMA perspective?
Yes, so when we put out the release in October about the guidance, we said two things. One, the fair dealing provisions are actually pretty long established within the 2014 FMC Act. So we expected firms to take immediate steps to ensure their advertising was consistent with the law. We also expected firms to ensure their current marketing practices and campaigns are in line with final guidance, and we said in the release at the time over the next couple of months. Actually, that media release is published on the 5th of October, so that 2 months grace period expires today, so it's good timing. And where there are any examples of marketing that takes advantage of vulnerable customers, particularly in the current COVID situation, we would just go straight to action. So where it's clearly trying to take advantage of situational vulnerability, there's no grace period for that.
Yeah, great. Thanks, Paul. Just perhaps in closing, a couple of last questions. What are the 2 or 3 things, Paul, that you would want people to take away from today's discussion?
I think it's that we all want the same thing, that fair treatment and the good outcomes for investors and for the financial strength of providers and for economic benefit generally. We all want the same thing, that the overall impression counts, that's what really counts, and that, just picking up a point that Hilary said about social media, it's that we understand that there are restrictions in word counts, but so do the providers. So that when you know that there are those restrictions on the medium or on the channel before you start to use it for advertising on a financial product, that is the reason to take extra care with what you say and how you say it. So those would be the 3 takeaways. Thanks.
Right, thanks, Paul. And Hilary?
I'd just say check your messaging with non-experts, just to be sure. I think beyond the requirements of the financial code for us, just not just the financial aspects. If you have someone in the background of your financial ad in the car not wearing a seatbelt, that's going to cause you problems. And be prepared to support your placement decisions. So not just the content of your ad, but where you put it and why.
Fantastic. Folks, there's one last question that just came through, which is around how any ongoing enforcement or possible enforcement action might be communicated. Paul, that's probably one for you.
As we've said, that there is generally a public aspect to these because the advertisement itself is public. So the correction for it will tend to be public as well, and because there's object lesson value for everybody in the industry. So, which is the flip side of being in forums like this, of course. Part of it's educative, and part of it is remedial. So, yes, there will tend to be a public element to anything that we don't like.
Fantastic. Folks, at 3:52, I'm going to say a big thank you to both Hilary and Paul for joining this conversation. I mean, I think it goes without saying, you know, the world's becoming a whole lot more complex. We're all consuming media in so many different ways, but as a sector and as regulators, confident, informed consumers are all of us, and we want that in the short term and the long term, and the role that advertising and marketing plays becomes pretty important. So there's been a really valuable insight, I think, into that conversation, and commend the ASA website, obviously, Hilary, for people wanting to find out more, and obviously to the FMA website as well. This has been recorded, so if there's anyone in your teams that may have missed out, absolutely, this will be back up on the FSC website shortly for a second watch. On behalf of all of us, again, Hilary and Paul, I really appreciate you taking the time and sharing your expertise and insights with us. So that was a virtual round of applause from the people out in Zoom land. And for those of you who may not be aware, tomorrow, just following on this discussion, we launch our final piece of research in the FSC, which is around women and financial capability and financial wellbeing in New Zealand. Really interesting discussion and panel that Clarissa will facilitate, and we'll launch the research as well. That's on at 3:30 tomorrow, and that will then close out our year. Again, thanks for watching. Thanks to our partners. Thanks to our speakers. Have an awesome afternoon, everybody, and thanks for watching. Bye for now.